Welcome to Constangy Clips, the series with tips on staying ahead of important legal challenges in the workplace and cyberspace. My name is Michelle Meek, and I'm a partner in Constangy's San Diego office. The new year is off to a fast start, and today I'm going to highlight 4 new California employment laws effective in 2026 that California employers should review for compliance now. These laws implicate hiring, onboarding, and pay practices, as well as notice and record-keeping requirements. First, the Workplace Know Your Rights Act requires that by February 1st, 2026, employers must provide a standalone written notice to employees detailing workers' compensation, immigration-related protections, union organizing rights, and other key legal rights. The California Labor Commissioner has provided a template notice in English and Spanish, with plans to offer additional translations in several other languages soon. By March 30th, 2026, employers must provide all employees with the opportunity to designate an emergency contact to be reached if they are detained or arrested. Employees are not required to provide this emergency contact, but if a contact is provided, employers must attempt to reach them in the event of an arrest or detainment. Employers should distribute the notice and collect new or updated emergency contact information by these deadlines. In connection with this review, you should also review your employment policies for necessary updates and consider a plan of action if one of your employees is detained or arrested at the workplace. Our second law, SB 513, amends Labor Code Section 1198.5 to make education and training records explicitly part of the personnel records that current and former employees have the right to inspect and copy. This law makes clear and complete training documentation a legal obligation, not just an HR best practice. Employers should update their record-keeping practices to ensure that training records contain required details, such as the trainer name, dates, duration, competencies, and certifications, and that the training records are maintained in the correct location for at least 3 years after an employee's termination. Third, AB 692 made so-called stay or pay terms unlawful in employment contracts with some limited exceptions. Effective January 1, employers generally can't require workers to repay training or credential-related costs if they leave the job. With this restriction in mind, you should review offer letters, employment agreements, and any training repayment terms, especially those referencing or tied to an employee leaving early. Our fourth law, SB 642, has revised and strengthened the pay equity and transparency provisions of California's Equal Pay Act. Notably, employers must include with all job postings a pay scale that reflects a good faith estimate of the salary or hourly wage range the employer reasonably expects to pay for the position upon hire, and not a vague, untethered pay range. Wages should include all forms of pay, including profit sharing and bonus plans. You should review job postings for compliance with this requirement and incorporate pay equity and transparency considerations into your pay and benefits reviews. As we start 2026, now is a great time to ensure that your company is compliant and ready. Thank you for watching. Be sure to follow Constangy on LinkedIn, Facebook, and YouTube for important updates and more tips for minimizing risk in this dynamic legal space.